Hi, I'm Emily and I am here with Maya Murphy's attorney, H. Daniel Murphy. Attorney Murphy practices at Maya Murphy's law offices in both New York and Connecticut. My question today for Attorney Murphy is, what do I do if my former spouse is not following the separation agreement?
So let's say you went through a divorce and maybe it was a contested matter that took a year and it went to trial and you had a whole trial with witnesses and documents and you had a decision that was issued by a judge and you now have a piece of paper which tells everyone what they're supposed to do and what is supposed to happen by virtue of that divorce. Or maybe you mediated and maybe you had lawyers help you both and put together a carefully worded agreement that memorialized your understanding of what the terms were going to be. And every word in that agreement was carefully chosen by you and your ex-spouse and by the lawyers. And every term was agreed upon. And now years later, maybe only months later, your ex is not following the agreement in some way. This could be by not following the provisions of a parenting plan or following, maybe it's a visitation access, maybe it's a vacation plan, or maybe it's something related to holidays or the regular day-to-day schedule. Or it could be financial. It could be someone not paying what was supposed to be paid or not doing it on time. And you're frustrated that all the money, all the time, and the energy that went into a piece of paper that's in front of you, whether it's a judge's decision or a separation agreement that was turned into a court order, is not being followed. The question is, what can you do at that point? Remember, that piece of paper, even if it was just an agreement that was drawn up by lawyers, and it's essentially a contract, it's also a court order. And there's some sanctity to court orders. They're meant to be followed, and it is punishable by law if orders are not followed. So what you need is called a motion for contempt. A motion for contempt is actually the shortened version of the phrase. It's really a motion for an order of contempt. And what you're asking the judge to do essentially is to find that the other side is contemptuously, deliberately defying a court order. And what do you need to show for that? Well, first, you have to show that the order is clear and unambiguous, that it is and was reasonably understood by the party against whom you're seeking enforcement, and that there was no vagueness or misinterpretation that was possible of that particular term. And secondly, you have to show that the other party is willfully violating that order. The court's going to consider at some point during the hearing, if you get that far, whether the party that's violating the order has the ability to comply and is deliberately choosing not to do so. Now, maybe he or she is not complying with the order because of some other issue. We see that often. Something that he or she thinks that she is owed, maybe related to some other part of the agreement. And this is called self-help. It's not a defense to a motion for contempt. It's people trying to make things right on their own outside of the agreement or outside of court authority. And it would be, on a motion for contempt, it's the moving party's burden to show these things: the clarity of the order, the willful disobedience of that order. And then the other side is going to have the option and ability, if the circumstances warrant, to claim as a defense that he or she does not have the ability to comply with the order. So what can the court do? What can the court do on a motion for contempt? Well, the court can and often does direct the party that's in willful noncompliance with the order to immediately comply. But the court also has other abilities and other remedies available to it. It has the authority to incarcerate a non-compliant party until the contempt is purged. That means until an amount is paid. Now, this sometimes happens in child support matters. That's usually the most common way people hear about it. But it can be applied in broader circumstances, that is incarceration. Also, the court can issue financial sanctions. The court has the authority and the power to make a party responsible for the other side's attorney's fees on a motion for contempt. The court has the authority to issue a financial penalty for any action or inaction that a party took, or even create a sanction going down the line if non-compliance continues. And the court can issue any orders that it sees fit to make a wrong right again. So if an order is not being followed, and there are circumstances and facts, and especially documents, which show that the order is not being complied with, and that non-compliance is willful, you should certainly speak confidentially with a family law attorney about what a motion for contempt might look like for you, and what would be the likely outcome given your particular facts. Thank you.